Good evening, everyone, and thank you so much for joining us. I'm very grateful to you all for attending. We had 3,500 sign-ups, which makes it one of our best attended Good Law Project Live events. We've got a sort of genuinely starry panel this evening to discuss what citizenship actually means in the real world. Good Law Project's got a team of people monitoring the social media channels, looking out for your questions. We're happy to take polite questions, we're happy to take rude questions, so long as they are interesting questions. Please do feed them in, and we'll leave time at the end for the panel to answer them. Introductions first of all. It was International Women's Day yesterday, so I'm very pleased to begin by introducing a husband of, Richard Ratcliffe, being husband of Nazanin Zahawi-Ratcliffe, who has been held hostage in Iran now for almost 6 years. Richard campaigns for her release, raises their 7-year-old daughter, and works as an accountant in North London. A thoroughly modern man. Ayesha Christie is a barrister at Matrix Chambers, specialising in public law, human rights, immigration and asylum. She's been involved in a number of recent legal challenges concerning the deprivation of British citizenship. She represented Liberty in Shamima Begum's case in the Supreme Court, which concerned whether she should be granted leave to enter the UK in order to participate in her deprivation of citizenship appeal. And we'll be talking about that case more later on. Yasmin Ahmed, the starry and very welcome fourth member of the panel, is Director of Human Rights Watch in the UK. Prior to joining Human Rights Watch, Yasmin was Executive Director of the multi-award-winning human rights organisation Rights and Security International. She held that post for 7 years, during which time she built a dynamic organisation with unparalleled expertise in national security and human rights, a global reach and sustained impact, which is a challenge to other campaigners on this panel. Rupert Skilbeck is a barrister and the director of Redress, which brings legal cases on behalf of survivors of torture all around the world, including Nazanin Zahawi-Ratcliffe. He was previously the litigation director at the Open Society Justice Initiative in New York, leading their human rights litigation. He also worked in the International Criminal Courts as the principal defender for the Khmer Rouge Tribunal, the director of the Criminal Defence Section at the State Court in Sarajevo, and the defence advisor at the Special Court for Sierra Leone. Wherever bad things are happening, Rupert is there, but it's correlation, not causation, I hope. So you'll hear very little else from me beyond questions. No one came here for me. Safer saying that Hannah Arendt, a noted scholar of totalitarianism, has talked about citizenship as being the right to have rights, the right to have rights. And there's not much really that exposes the importance of that right as clearly as what's happening in Ukraine at the moment. What does it mean to have a relative as a British citizen? What we're finding out now is that it's becoming a contingent right, and perhaps somewhat hollowed out. Enough from me. Question first for Ayesha. Ayesha, can you tell us about the expansion of the deprivation of citizenship powers over the last years, and their impact in particular on non-white British citizens?
Yeah, so over the last 20 years, there's been a gradual expansion of the power to deprive a person of their citizenship. Before 2002, the government only had the power to deprive people who'd acquired their British citizenship by naturalisation or registration. But in 2002, the government first introduced the power to deprive persons who held their British nationality by virtue of being born British. And at that point in time, the threshold for deprivation required the Secretary of State to be satisfied the person had done something that was seriously prejudicial to the vital interests of the UK or a British overseas territory. And this power couldn't be exercised if it would make a person stateless. So the only people who could be deprived were those with dual nationality. And as we've seen in a number of recent legal challenges, individuals may not know that they're a dual national, and they may not have any connection with their country of second nationality. But what this did was essentially create two classes of British citizens: only dual nationals who can be stripped of their British citizenship. And it has a disproportionate impact on non-white British citizens because they're much more likely to have parents or grandparents with a connection with another country, and may be considered nationals of that country. And there was some interesting analysis conducted by the New Statesman on 2011 census data, which suggests that 41% of people from non-white ethnic minorities in England and Wales could be eligible for deprivation on the basis that they hold dual nationality, compared to just 5% of white people. And after the 2002 amendment, there were further changes. So in 2004, or prior to 2004, the Home Secretary couldn't make a deprivation order whilst a person was appealing against the decision to deprive them of their citizenship, which meant that an individual remained a British citizen whilst they were appealing the decision and until that appeal was concluded. But the law was changed in 2004, enabling the Home Secretary to deprive a person of citizenship whilst they're waiting for their appeal, which means that they'll be deprived of their citizenship unless and until they succeed in their appeal. And then just 2 years later, there were further changes. So the threshold for depriving a person of citizenship was reduced. So it went from seriously prejudicial to the vital interests of the UK to allowing the Home Secretary to deprive a person of citizenship where it's considered conducive to the public good. And this is a much lower threshold. In fact, it's the same threshold that the Home Secretary applies when making decisions to deport non-British nationals. And what we see is this conflation of the rights of dual nationals with immigration rights. So this is a very broad power, and we've seen it's not simply exercised in national security cases, and a real very serious intrusion on the rights of citizenships for dual nationals. So up until 2014, the Home Secretary couldn't deprive a person of nationality if it would make them stateless. But in 2014, the law changed again to allow the Home Secretary to deprive people who had been naturalised as British of their citizenship. So again, the older test was applied here. So if a person who's been naturalised as a British citizen has conducted him or herself in a manner seriously prejudicial to the vital interests of the UK, and the Secretary of State has reasonable grounds for believing that that person may, under the laws of another country, be able to become a citizen of that country, then she can deprive them of their citizenship. So what this means is that the Secretary of State now has the power to deprive naturalised citizens, even where that would make them stateless. And if ultimately that person is denied citizenship by the second country, they may permanently become stateless. And then in 2018, there were further amendments. The Home Secretary made regulations which allowed her to deprive a person of citizenship by simply placing the notice of decision on an internal Home Office file. Now, this was found to be unlawful by the High Court and Court of Appeal in a case called D4, which we may come on to discuss. But it's the latest in a string of amendments that have eroded the right to British citizenship, which has a disproportionate impact on dual nationals. You're on mute at the moment, Joe.
Schooled. Thanks, Aisha. I mean, I guess as I was thinking about that answer, just listening to you, what really struck me was the impact that having citizenship that is contingent has upon your ability to exercise the rights and privileges of citizenship. The fact of your citizenship being contingent might make you feel uncomfortable about exercising the right to protest, might make you feel uncomfortable about kicking out at government. So it doesn't just have an impact on those for whom citizenship is removed. It has an impact on everybody whose citizenship is rendered meaningfully contingent. Yasmin, I just stopped at the amendments in the Nationality and Borders Bill. What do those amendments do? And why do you think they've caught the public imagination, not in a good way, whereas other changes that Aisha has outlined have sort of gone uncommented upon, at least by white people?
Yeah, thank you, Joe, and thank you, Aisha, and the rest of the panelists. It's wonderful to be here on this panel talking about this really significant issue, and really helpful to have the background that Aisha provided, and obviously really congratulations for the work that she's been doing, which has been so critical on this issue. Well, I think that, first of all, to your point about the precarity with which this puts people in, and the discrimination that people suffer as a result of it, because it certainly means that if you are someone who has another nationality, or now, as Aisha said, the potential ability, and you might not even know that you have the ability to have that other nationality, you're in a much more precarious position. And as you say, by virtue of that, the way that you behave and the things that you do will be informed by that. And that's a kind of tier of society and of what we're creating and the kind of atmosphere that we're creating. And as you said quite rightly, citizenship is a gateway right. It provides you with all the other rights of protection and the positive rights and the negative obligations of states that are then taken from you. And that's why under international law, there was obviously the Statelessness Convention, and so much effort has been put in to ensure that people are not made stateless, which essentially is what can happen de facto as a result of what the UK can do. In terms of the Nationality and Borders Bill, as Aisha mentioned, the amendment would essentially mean now that the UK government is not required to serve notice on somebody in particular to tell them that their citizenship is going to be or has been deprived, and therefore potentially scuppers the ability of that individual to appeal against that decision. And the real significance of that is obviously you don't have those appeal rights if you don't know that you've had it deprived. And also you only have a certain period of time within which you can appeal. So it's very significant. And as Aisha was saying, the government have attempted to do this before, and they have often done it. And they have done it. I've worked quite a lot on women and children in Syria, in the Kurdish detention camps in northeast Syria. And a lot of those women and some of the men also in the prisons, the British men in the prisons and the women in the camps it's been a pretty much systematic policy from what we can see that the British government has deprived them of their citizenship. And in a lot of instances, they will argue, well, we just put it on file because we can't serve the individual. And this essentially sediments that. And so that has really significant implications for individuals and their ability to challenge their deprivation. And then it has flow-on effects, obviously, to the children of those women who are deprived and future children that those women may have as well. So it's very significant. In terms of why it's captured the imagination, it's an interesting question. And I wonder to what extent it is because it sits within the context of the Borders and Nationality Bill, which in itself is really a bill that systematically undermines the protection architecture in the UK. And it sits within that, and it highlights that this is not just about a procedural issue about someone being served or not, but it serves to remind us that, in fact, this is about a systematic policy of the UK government, which is currently doing, which is essentially depriving people, including those that are seeking asylum, but including others who may be deprived of their citizenship, fundamental rights. And so I think that's probably partly why it's captured the imagination of individuals. And I think also, really the situation of Shamima Begum and other situations which have really highlighted what this actually means for individuals in this situation. A person who was a minor and likely groomed and gone to Syria, who now has lost 3 children, is stuck and is indefinitely detained in northeast Syria.
Thank you. Yeah, it's been really, really interesting. I was as I was thinking about what questions I wanted to ask, I remembered the first time I ever took a flight and looking inside the sort of cover of my passport. And if you look inside the cover of your passport, if you're a UK citizen, you find the words, Her Britannic Majesty, Secretary of State, requests and requires in the name of Her Majesty all those whom it may concern to allow the bearer to pass freely without let or hindrance, and to afford the bearer such assistance and protection as may be necessary. And Richard, I sort of wondered about that with you. There are probably few people in the world who have had to ponder on those words for as long as you have. What do you think they mean in the real world?
Yeah, no, I think it's a really good question. Thanks, Joe. I think that's exactly right. Our story, and for those, I'm sure most people will know our story, but Nazanin went to Iran to see her mum and got picked up and has been held. At the beginning wasn't clear why, and then been held hostage for now getting on for 6 years over what is essentially a government dispute between Iran and the UK over some money, nothing to do with us. And I think that's right. I read the inside page of the passport thinking, okay, well, that means the government will step up and will protect, and probably kind of, I mean, it's sort of naive middle class layman's expectations, but that the government's first job is to protect people, and it may not get it right all the time, but in principle, that's what it's there for. And I certainly, knocked on the door of the Foreign Office and have had a long running, at times private and at times very public criticism of the government's failure to protect. I think our story's interesting in that, it certainly feels like there's, in our story, it's not that in Nazanin's case, she's been walled off from citizenship. And in fact, I remember, our press coverage is a lot more positive than, say, Shamima Begum's is. And I remember us being on the front of the Times newspaper, where Gabriella our daughter was one picture, and Shamima Begum was the story next to her. And it was sort of good dual national, bad dual national, put next to each other. But I've still been struck, and it's something that Rupert can talk in much more great insight than I can. But the reluctance of the government to protect its citizens when they go across the border. No doubt there are reluctances within the UK territory, but when you step across the borders and you go overseas, actually all protections that the government provides are discretionary. They can choose to protect, they can choose not to, they can choose what they do. And there is a sort of an expectations gap between what you think the passport is telling you and actually what is really going to happen. And there's a whole array of deflection tactics that the government will use to avoid making it too clear that they're not protecting, also to avoid making it too clear that it's not doing very much. Which, I sound quite cynical as I say it, but over time we've discovered more and learned more about how to, prod, in fairness to, what are very well-meaning diplomatic staff, but who are tasked with protecting national interests, not protecting the interests of an individual. And there is genuinely no set of obligations that they sign up to. I remember quite late on in the period, we've been sort of going about 3 or 4 years, our lawyers asking the government, okay, so, what, I know what I think your obligations are as a government, but what do you think your obligations are? And if you want to call her a consular case, so a regular British citizen has been detained overseas, what do you think your obligations are? If you want to acknowledge that she's a hostage, what are obligations? If you want to acknowledge that she's a victim of torture, what are obligations? And if you want to acknowledge that she's a protected person because the UK afforded her diplomatic protection, what are obligations? And in all cases, it was none, 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 and none. And I thought, gosh, that can't be true under international law. That can't be true under, because there are international obligations. That can't be true. And, that you're saying, listen, something like diplomatic protection, which essentially means that a recognition of injustice to Nadine, and that injustice is treated as a state-to-state dispute. You're telling me that has no consequences on the state? So I think it has been a long lesson for us, and perhaps a sort of a naive realization that civil obligations, as they're understood by the British government today, by the Foreign Office today, are has no. I mean, it will, if you make enough noise and cause enough trouble, and we've obviously been very public and made lots of noise and caused lots of trouble, you will get attention. If you have the ability to get on Radio 4, you're more likely to get that attention than if you don't, and it is definitely regressive in that sense. But actually, the dangers of discretionary government in that sense, particularly where it matters on things like torture and arbitrary detention and so on, it's an area I think that, thankfully at the moment cases like Nasneen's are really rare, but as they become more common, it definitely exposes different people to different levels of danger.
I guess that's one of the things that pesky lawyers can do, is they can move these issues from matters that are in the discretion of government, which benefits the sharp-elbowed and the well-connected, into territory that is more objective and perhaps fairer. We've talked a lot about the Nationality and Borders Bill in Clause 9, and for those who are interested, we tweeted out just a couple of moments ago a very lengthy analysis of Clause 9 from Raza Hussain QC, Jason Pobjoy, and Eleanor Mitchell, a sort of but for the omission of Aisha, a very starry team of lawyers. Rupert, so I just noticed that this was the 30th anniversary this year of redress. Really interested in how citizenship impacts on your work, and whether you think the impact has changed over time. Has citizenship become hollowed out, or is it a relatively static concept, do you think?
Well, redress was founded 30 years ago by Keith Carmichael, and he's actually one of the people, the fellow in the blazer in the picture behind me. Keith was a British businessman living in Saudi Arabia and was essentially arrested completely arbitrarily. It was a shakedown to try and get him to pay a bribe. Held in appalling conditions, ultimately tortured while in detention in such a way that broke his back and left him with permanent disabilities. And when Keith eventually got out, he realized that there was no legal NGO around that was able to help him claim reparation for what had happened to him. And it's slightly concerning if you think about the long view. Keith tried to bring a case for 30 years. He's never succeeded in getting justice for what happened to him, because essentially the Saudi government has state immunity when it comes to civil claims. And he attempted to change the law through the Torture Damages Bill that was a private member's bill in the House of Commons in the late 1990s. But he never managed to make that work. And one wonders that if 30 years ago, the British government and others who had been detained, many foreign nationals were being shaken down in the same way. The Americans ended up allowing legal claims to be brought. Massive multi-million-pound dollar claims were made in the US courts. But one wonders if there'd been a more considered response, that the Saudi authorities wouldn't be so brave to go around torturing people these days. And we wouldn't have had the situation where a journalist was murdered so horrifically only a couple of years ago. So perhaps if more had been done to prevent the sort of torture that was fairly standard at that time, the world would have been different. Unfortunately, the situation hasn't changed very much. In fact, it's probably got worse. Redress did some research on this issue about 3 or 4 years ago, and we published a report called Beyond Discretion that looked at this problem. And from the figures we could get from FOI requests and all the rest of it, there are about 5,000 to 6,000 British citizens who are arrested abroad every year, and approximately 100 to 120 of those alleged torture or some other form of ill treatment as part of that arrest process. That has gone up in recent years. It used to be about 50 a year. It's now gone up to more than 100 a year. So it's a significant amount of British citizens who seemingly are being ill-treated abroad. Some of them make their way to redress, and so we will sometimes bring cases where we're able to try to do so in order to bring some form of recompense for them. And we, through this report, looked at what was going on and the problems that are there. And the main issue is that the action, as Richard has very accurately described, is completely discretionary. And so you've got the 1968 legislation that purports to put in place the legal basis to consular assistance that takes place, but it's all completely at the discretion of the government. The policies are rather hidden away. There's not a huge amount of transparency. There are some ministerial statements. There are some internal guidance documents. There are various other internal documents, but there's no one single document that puts it out there and says what's going on. And what we looked at through our report was that this lack of a right to consular assistance, only the discretionary approach, meant that families often felt that they were being let down. The approach often is, well, you have to trust us to do the right thing, but you don't have the right, a justiciable right, to say that you have to do this, and if you don't do it, we will take you to a court to see if you've done it reasonably or not. That right doesn't exist. And what happens is that level of scrutiny is not present. It's all done in, many families feel that it's done in a way that gives them very little power to push things in the right direction. And despite the huge efforts of the consular team, which are undoubtedly vigorous in many cases, many families feel let down by this process. And so that's the difficulty we have. While the right to consular assistance is not properly there in British law, it's merely a discretion, then it puts families in a very difficult situation unless they have the wherewithal and the energy to do what we've heard about, to make sure their cases are in the forefront of the political and public agenda.
Thanks, Rupert. And fatal error on the part of the scheduler of this event to have two lawyers, one asking questions of the other on a single call. But Aisha, returning to you and just looking at Clause 9 through the lens of a constitutional lawyer, and recognizing that it can deprive someone of the right to know a decision that has been made about them. How does that sort of sit within what you as a constitutional lawyer understand to be our constitution? I was waiting for this moment to come. You're on mute, by the way.
Yes, well, it doesn't really sit very well with what's been recognised by the courts as a right to be notified of a decision which has an effect on you, as well as, for example, the right to make representations in advance of a decision being made that affects you, or indeed subsequent to a decision in the hope of changing the decision maker's mind. So it's quite problematic from that perspective. But another point that I would want to make about a Clause 9 is that not only does it dispense with the notification requirement, and does so in circumstances where the Secretary of State is now no longer required to sort of take any steps to reasonably search for information about a person's whereabouts. But it also hugely problematically dispenses with the notice requirement retrospectively. And that's something we haven't yet discussed. But what this means is that an individual who hasn't previously been given notice, which the courts have found to be unlawful, in those instances, the failure to give notice will be treated as never having affected the validity of the deprivation order. So again, this is a sort of worrying constitutional amendment, and it has impact. It has an impact not only on the individuals affected, but also on, for example, their children. If an individual was never lawfully deprived of their citizenship, were the children born to those individuals British citizens? What happens to those children if the order is given retrospective validity? It's hugely problematic. Joe, you're on mute again.
Impossible to appeal against a decision that you don't know has been made. And you also end up feeling rather cynical about the breadth of the entitlement on the part of the Secretary of State not to notify. What is the good policy reason for having a provision that is so very broad? Why do you need those broad powers? And of course, you ask those questions and the Home Office gets stuck in on social media with all sorts of blandishments about them only being used for good reasons. But those of us who are lawyers will know that if the Secretary of State comes to want to use them for bad reasons, he's not going to be constrained by the fact that civil servants said on Twitter, don't worry, we won't misuse this very broad power. And that's what troubles me. You introduce this stuff at a moment in time at which the population feels more or less comfortable with it. But it puts enormous power and discretion to do awful things into the hands of a later government. Yasmin, just returning to you, I guess the best known case in this space is Shamima Begum's case. Could you just remind us of the facts and tell us what the decision means for those, for example, who were encouraged by the Foreign Secretary to go off and fight in Ukraine?
Yes, so obviously Aisha will also be able to speak to the Shamima Begum case and probably in more detail than I will. But we've been in my current role and in my previous role working a lot with women and children who are in northeast Syria from a number of different countries, including the UK, who are indefinitely and arbitrarily detained there. One of whom is Shamima Begum. And as you noted, so Shamima Begum was a minor, 17, when she went out to northeast Syria. There are very strong suggestions and evidence to suggest that she was groomed online and potentially trafficked out to northeast Syria. She had 3 children while she was there. She lived under the Islamic State. Then she was eventually, with the fall of ISIL in northeast Syria, was captured by the Kurds in the region and is in detention. She was in the Al-Hol detention camp first for a long period of time and is now in Al-Roj detention camp. There are currently 2 detention camps with thousands of women and children in conditions which have been found by the UN Special Rapporteur to amount to torture because they are such bad conditions, in addition to being obviously arbitrarily detained with no having been charged with no crime and there being no due process at all. So what happened in her situation, she was like many other British women and men who went out to northeast Syria, upon the British government finding out that they were there, were deprived of their citizenship. In her case, she challenged the deprivation of citizenship. And it obviously has been finding its way, the case has found its way through the courts. The most recent decision, there's obviously the substantive question about whether the stripping of her citizenship was in fact lawful or not. But there was a preliminary question which the court needed to ask itself, which was whether she was able, in fact, to have a fair trial or a fair hearing in relation to her appeal while she was in northeast Syria, given the fact that she's in a detention camp, her lawyers can't get proper instructions, she's not able to essentially be able to instruct them properly and participate in any hearing adequately. And this is obviously a significant problem, and one in which is actually kind of wrapped up with the broader government strategy on this, in that the UK government will deprive people of their citizenship when they are abroad, which makes obviously the ability to appeal a lot harder. So this is a tactic which is essentially used, so it becomes much more difficult to challenge it. So the court found in the case, the Supreme Court found that that whilst she wasn't able to have a fair hearing and engage in her hearing, that nonetheless those rights could be suspended in the current circumstance, which I think is a wholly unsatisfactory position, particularly in the current context where someone like Shamima Begum is sitting in essentially a legal black hole, has no ability to get out of detention. She's detained. She can't challenge that detention. And now the government is saying we've deprived you of your citizenship, and the courts have said, well, in your ability to challenge that, even if you are not able to adequately challenge that according to legal standards and protections, that nonetheless still applies given national security and other concerns. So that's where we find ourselves now. The second part, the substantive aspect of her hearing, will potentially go forward, and obviously it's a question for her legal team about whether, in fact, you want to be challenging the substantive deprivation in circumstances where you're saying it's okay that we engage in this when her right to a fair hearing and participation in that hearing is being put in abeyance. She essentially can't do that. But if they do, and as they do move forward with the case, there will be the question about whether it's been lawful to deprive her. And as Aisha mentioned, in the case, there will be the question of whether, in fact, she is entitled to Bangladeshi citizenship. And Bangladesh has been very clear that she's not entitled. They say she's not entitled, and that they will not permit her to go to Bangladesh. So in fact, she does not have access to another citizenship. But the question is whether the courts will find in favour of the government any such decision as to, in circumstance where they say, well, there's a possibility to do so, and thus it's lawful to deprive. And I think what's really important, Joe, is to think there's all these legal questions around access to a fair hearing and around deprivation of citizenship. But I think it's really important, like in the case of Nazanin and in the case of Shamima Begum, to think about, well, what is the implication of these laws or the lack of protection. In the case of Nazanin, it's a continued arbitrary detention, and her life completely shattered, and the life of her family completely shattered. And in the case of Shamima Begum, it's essentially being, indefinitely detained in northeast Syria, having had 3 children die in that circumstance, and no ability potentially to, and essentially being rendered stateless in that circumstance.
Thanks, Yasmin. That's really, really helpful. Richard, in the real world, is this all just a matter of politics? What have you been told by, you've seen off a number of foreign secretaries, great credit to you as a campaigner. What have you been told by them about the real reasons for Nazanin's continued detention?
I suppose that's right. I'm obviously the non-lawyer on the panel. I find that, if you look at our story, the law plays an important role in the reasons in which Nazanin is held, in the battles we have with the government to try to get them to do something. And it has always felt that it's political. In our case, it's very clear at this point that we are held between 2 states who are fighting, and Nazanin is a bargaining chip. And there's obviously a different set of interests for the 2 states. So from the Iranian side, they will make that reason explicit, and periodically they will, tactically abuse her, tactically squeeze different ways to get a reaction from us and a reaction from the British government. And the British government's instinct, as like any other sort of kidnapping case, is to downplay that and to not be pressured and not to be pushed around. So you have an inherent asymmetry, I suppose, in that getting the British government to acknowledge the violation of rights is a much more of an uphill battle than I was expecting, because they've got a structural interest not to notice them. And certainly, famously in our case, the Prime Minister, when he was Foreign Secretary, spoke out in Parliament and said she was trained journalist when she wasn't, and it caused all sorts of cynical stuff subsequently. But actually, when he spoke those words in Parliament, that was the first time any British minister had acknowledged any violation of Nazanin's rights, which was 18 months into it, and then all sorts of horrible stuff had happened. So our immediate reaction was quite pleased that day. It was only afterwards, when it all spiraled, that it took a different course. And to talk to a little bit of what Rupert was saying about the importance of families feeling they've been let down in situations of torture. I think the facts are that 100 British citizens a year report torture to the Foreign Office, and I think we are the only case in the last 20 years where a British minister has acknowledged that torture, and the government has a protocol of what it will do in such an instance where torture is acknowledged, which essentially is to push the detaining authorities to investigate and to credibly check what's happening. And even in our case, they haven't done it. So they have asked once, but then, set against other sort of diplomatic priorities, it's felt it's not appropriate to push too hard, and so on. I think the other thing I'd say as a non-lawyer, for me, part of citizenship is apart from sort of equality before the law, it's also about accountability, and getting. I find it very hard to get the government to explain itself, to be honest about what it's doing, to be honest about the situation, what's going on, and that kind of really fundamental part of what it means to live as a citizen, where the government's job is to give an account of itself every so often. I find that's really eroding these days, and the Foreign Office has always been a secretive operation, and partly for good reasons, and partly because culturally that's the way diplomats work, where they do like to keep things behind closed doors. But I do think, in terms of policy, the refusal to acknowledge what's going on, and the refusal, the line we would get sent to Parliament all the time is that they won't give a running commentary on Nazanin's case. And we're about as good as it gets, because at least they have to answer us. But I think it's such a fundamental problem we have going forwards, that you have discretionary politics that doesn't need to answer to anyone. It's a recipe for injustice.
And Richard, I wouldn't forgive myself if I didn't ask. Why do you think that it's Nazanin's case that's been the only one that's caused torture to be acknowledged by the Home Office?
It's a really good question. I think we've been going quite a long time. It's quite emotive. I think we've actually been lucky. We had the personal commitment of a run of foreign secretaries. Part of the distinctiveness of us is that not many families like us get to meet the foreign secretary, because it's discretionary. The minister can cut through advice and can make decisions and can say things that would not be allowed for an ambassador or a lower level to say. But you need to get in front of the minister a number of times before they're gonna get it emotionally as well as practically. I think outside of Nazanin and the other Iran hostage cases, I can't think of any other British citizen or the family of British citizens held overseas who've been able to meet the Foreign Secretary in the last couple of years. So it's probably as simple as that.
Thank you, Richard. That's really kind. And finally, before we come to audience questions, Rupert, redress works internationally, or not just UK based. Is the reality that how the United Kingdom responds to these awful situations just like how everyone else responds to them, and it basically boils down to politics?
Yeah, we've had some successes on occasion of getting connections at a high level. We also represent Jagtar Singh Johar, who's a British citizen who was tortured in India, very brutal execution. He is alleged to be part of a very complicated and broad conspiracy, and the government was prepared to raise that. Theresa May, when Prime Minister, raised it directly with the Prime Minister of India. So there is very sometimes high-level connections when it's a clear case of torture such as that one. Other countries are a bit more aggressive. In the United States, Congress is very involved in pushing cases and pushing the government to respond in a much more active way when American citizens are trapped abroad. Some countries are more well known for being more transactional in their approach and ensuring their citizens are released much more quickly by being prepared to some extent to cut deals, which perhaps isn't a feature of the British government's approach to such situations. And so, yes, we do see other situations where governments are perhaps more active and more prompt in their responses.
I'm so grateful, Rupert, not least because you've hit the 6:45 mark perfectly, allowing me to deliver the promised 15 minutes to audience questions. What a pro. So first question from Pauline, and really I think probably a question, Yasmin, for you. What can we do to help people? Because writing to an MP doesn't really seem to work. Is there more that people can do?
It's a very good question. I would say that whilst one might feel that writing to an MP sometimes feel not as impactful as you would hope, I would say to people that it continues to be a really important way of having your voice heard, because I think particularly someone who's following, and I think people on the panel, people who are following parliamentary debates and the pressure that those even parliamentary questions and issues that are brought up in Parliament continue to ensure that the government is held accountable and that there are questions being asked. So I would say continue to do that, continue. I think also thinking about how more broadly you can engage and assist. There might be organisations that are working on or for these issues that you might be able to volunteer for or support. I think also, I also think it can't be said enough how important the public narrative around this is, and how we as individuals should feel empowered to be speaking about these issues within our own communities and raising awareness of these issues. Because I think a lot of what happens with respect to statelessness and the deprivation of citizenship happens under the guise that people don't care. And I think we need, as a community and people, to make very clear through how we're speaking and in social media and other means that we actually do care, and that this is not going to happen under our eye without concern from us and us raising issues. So really, it is very difficult, but I think that the political context within which this is happening is that governments continue to use fear and minorities and other sort of scapegoats as a way of, like Aisha said, expanding their power, which, as you said, was very clear that the implications that have not only now but going forward. And so I think more generally, being involved in campaigns, directly engaging with your MPs and discussing these issues and being engaged on a civic level to make clear that this is not being done in our name is really important.
Yeah, it's not like you get to write a letter to your MP and they'll automatically change their mind. But it's also not true that writing to your MP has no impact. I think if you send a letter from the heart rather than something that's sort of automatically generated by a campaigning tool, your MP will engage with it. Most MPs, in my experience, are pretty decent and hardworking. I may not like their politics, but they went into politics for a reason and they will engage. I think the other thing that's really important, and this is something, Richard, you've done incredibly well, is just keeping an issue in the public eye. These things aren't resolved at the drop of a hat, and everyone has a very short attention span. Just being able to keep an issue on the top of the agenda. Forgive me, Richard, I want to take some more of the questions. The second question is from Nigel. What does it actually mean to be stateless in real life? I mean, is it like you're Tom Cruise in the airport? Is it? What does being stateless actually mean for how you live your life, Aisha?
So if you're stateless, you don't have the right to live in a particular country. You don't have a nationality. And I mean, perhaps I'll just start by reminding everyone that the right to a nationality is enshrined within the Universal Declaration of Human Rights, Article 15. And as Joe said at the beginning of today's session, it's been described as the right to have rights. So not only do you not have the right to live in a country of your nationality, but in whatever country you find yourself, you may not have the right to access education, to access healthcare, employment, to own property. You may well also face restrictions on your freedom of movement, or you may be held in detention. And I've represented a number of individuals who are stateless, who have been detained within the UK. So there's a whole range of rights that citizens take for granted, that if you are stateless, you won't be able to avail of those rights.
And perhaps it's good, there's some good examples around the world as well that the Open Society Justice Initiative was trying to litigate. There's a whole group in Kenya, the Nubians, who were never recognized as Kenyans for 50 years. And exactly as Aisha says, they couldn't get jobs, they couldn't get married, they couldn't travel because they had no ID cards, they couldn't do anything. And that case is currently before the African Commission on Human Rights. And then there was a group of 18,000 Slovenians who were raised at the time Slovenia became independent from the citizenship register. So they ended up trapped in Slovenia with no rights whatsoever. And it's completely impossible to live your life when you're put into that situation. It's an extraordinary, complicated and very invisible problem because no one's really interested in this issue either. So they go unnoticed.
I've been acidly reminded in the back channel that I have set up with my staff that it was Tom Hanks in the airport, for those who were yelling at their screens. Question from Gary. Will citizenship be hollowed out further by the police and crime bill? How might it affect human rights of political expression? And in a sense, this comes back to that point about contingent citizenship that we were discussing earlier. Rupert?
I mean, I think someone mentioned it earlier. If you are a person with second-class citizenship in this country, you'd be very careful of going to a demonstration where you might get arrested. What's going to happen? Those of us who've lived abroad, I've lived in quite a few interesting places. And when you're living somewhere with a visa where you don't quite have the full right to be there, you have to be much more careful about what you do. If you're living in America, you don't criticize the American government too obviously on an H-1B visa because you might not get it renewed, particularly if you're doing human rights stuff, accusing them of CIA torture and things like that, which I was. So you can see how easily you fall into this second-class status where you are constantly checking yourself. And yes, political expression, I can see why people who have that second-class citizenship that is now being created would be extremely careful as to what they do.
Yeah, that's a really, really helpful way of looking at it. Thank you. And of course, in a sense, if your visa isn't renewed, I mean, that's obviously a pain, can be a very serious pain, but you have a country to go back to. What we've been hearing is that if your citizenship is removed, the repercussions are far more serious and unknowable. Question from Mohammed. Does Clause 9 allow the government to deem the guilt of an individual in secret without sharing any details with the individual and to take their citizenship away? Is that the sort of net effect, Aisha, of where we've got to?
Well, yes, it is, because at present, the legislation requires the Home Secretary to give a person written notice. And when they send the decision letter is required to set out the grounds for depriving a person and give an explanation of the reasons, as well as notifying them of the right of appeal. So if the Secretary of State is no longer required to give a person notice, then not only will the person not know that they have been deprived of citizenship, but they also won't know the reasons for deprivation.
And indeed, you may not even know that you have been.
You won't know. How on earth would you know that you have been? You wouldn't. You're not being given notice. It's being put on an internal Home Office file. As the judge in the High Court said, you can't give someone notice by putting it in a desk drawer and locking it.
Yeah. And a question from Jane, and probably the last question we'll have time for. Has the loss of EU citizenship increased our lack of ability to fight the UK government's assault on our citizenship rights? What were the component parts of EU citizenship that departed when we left the European Union? Does anyone want to try this, or shall I have a go?
I'm going to defer on that one.
Was that a suggestion, Richard, that I have a yes?
Happy
I feared that would be so. EU citizenship was always a sort of adjunct citizenship. So it expressed an idea about a sort of dual identity, a national identity and a European identity. And it gave you some very important rights, including the right to live throughout the European Union and rights to sort of democratic representation in the European Parliament. It was never constructed as an alternative to national citizenship. I have a funny feeling because back in the day, we litigated a case about EU citizenship. I have a funny feeling that there is some learning in the courts about the relationship, the guarantees that EU citizenship gives you in respect of retaining national citizenship. And I think what the case law says, if I remember it rightly, which is a bit of a coin toss, to be honest, is that that European law says that EU citizenship is guaranteed to national citizens. EU citizenship can't be removed arbitrarily. Let me use that as a shorthand. And so it follows that national citizenship can't be removed arbitrarily because it would remove the gateway to EU citizenship. So in fact, if that recollection is right, it does, for those still in the European Union, give you a sort of an extra layer of protection in respect of at least a world in which you'd be rendered stateless. And I think a world in which your citizenship stemming from nationality of an EU member state would be lost as well.
Joe, if there's a minute, I could just add something to that.
Please.
I mean, I think with the loss of our EU citizenship also comes the loss of reliance on the European Charter of Fundamental Rights. And there's been a lot of helpful case law from the Court of Justice of the EU concerning issues like arbitrary decision-making, or, for example, the amount of information that you need to be given in, for example, a national security case. And so those are aspects that are relevant to a citizenship appeal. And those watching may not all be aware, but in national security appeals, the bulk of the hearing is often heard in closed proceedings. So the lawyers directly representing the individual concerned are not present to hear the national security case against their client. And there's been a lot of helpful decisions from the European Court about the amount of information that we need to be provided with for an individual to essentially have the gist of the case against them. So I think that there's a sort of lots of procedural losses that flow from our exit from the EU as well, which impact on our ability to fight loss of citizenship cases.
I'm incredibly grateful, Aisha, and indeed to the rest of our panel. I found it an incredibly illuminating discussion, and I hope those of you watching from home or in your offices have found it helpful too. If you are interested in Clause 9, once again, we shared on social media a link, and you'll find it on goodlawproject.org. It remains only for me to thank Richard, Yasmin, Rupert, and Aisha for attending this evening. Thank you so much.
Thank you, everyone.
Thank you so much.
Thank you.